Welcome back to CJ213. We're going to be looking at prisoners' rights today from Chapter 8. So, yes, we are. We're exploring one of the most important chapters, prisoner rights. This chapter looks at how incarcerated individuals really interact with the law, what rights they retain, how courts have shaped modern corrections. Um, I can tell you that prisoner rights are not an abstract concept. They really do shape daily operations, officer responsibilities, inmate behavior, and institutional safety. So again, we'll go side by side, really unpack what prisoners' rights really mean in practice. So, what do we mean by prisoners' rights? A right is a claim that someone else, whether the state or another individual, has a duty to honor. In corrections, defining prisoners' rights is difficult because people disagree on what rights someone should retain after committing a crime. Three viewpoints that shape this debate is the legalistic due process view, the crime control view, and the humanistic view. Staff often lean towards crime control, the that model, while courts kind of pushed institutions into recognizing due process from a humanistic perspective. The tension affects everything from searches to discipline to medical care. So, the legalistic due process view, prisoners retain rights that the Constitution, Congress, or state law specifically grants. Nothing more, but nothing less. Officers have to follow these rules even in maximum security settings. In a crime control view, prisoners they forfeited their liberty when they committed a crime. Confinement in itself is the punishment, and discomfort inside prison helps deter future crime. Now, the humanistic view, this is treating inmates humanely, reduces resentment, it increases rehabilitation. When I worked with long-term inmates, I saw this treating people fairly often prevented violence, and with that, one of the byproducts is respect, and respect always lowers tension. So the foundation of prisoners' rights law, the foundation of prisoner rights comes from several sources: the U.S. Constitution, the Bill of Rights, the most relevant 4th, 5th, 6th, 8th, 14th Amendments, state and federal statutes. And corrections officers must understand that constitutional rights don't disappear at the gate. They're narrowed, but they're not erased. So there's also several legal mechanisms that inmates use. Legal precedents, that's the case law that sets the standards. The federal civil rights lawsuits, especially Section 1983 filings, the writ of habeas corpus, challenging unlawful confinement. Habeas petitions and the 1983 lawsuits were common. Many inmates learned to use law effectively, and even small procedural errors by staff could end up under federal law. So, developing prisoners' rights. Originally, courts viewed inmates as slaves of the state. In Ruffin versus Commonwealth of Virginia, 1871, the court said that prisoners essentially had no enforceable rights. So this led to the hands-off doctrine. Courts refused to interfere in prison administration. Back then, society showed little concern for prison conditions, and most complaints were dismissed as whining about privileges. When I started my career, some older officers still had that mindset, but the legal landscape had changed dramatically by then. And modern officers must understand that they are 100% accountable under constitutional law. So from 1966 to 1980, we saw this 180 degree reversal in case law. It was the high watermark of prisoners' rights movement. Courts dramatically expanded inmate protections, and many cases included these three here. Procurator versus Martinez, 1974. This limited censorship of mail. Wolf versus McDonald, 1974. Due process in disciplinary hearings, and then Estelle versus Gamble, 1976. This is the established the right to medical care. These cases shape daily life in prisons. Every disciplinary hearing I witnessed had to follow Wolf standards, due process, notice, evidence, impartial review. Medical care had to be documented, so it met constitutional requirements in the Estelle and Gamble. So after 1980, the courts began shifting back towards a crime control model. The restraining hands doctrine reappeared, and we had these four cases. Montaigne versus Himes, 1976. This reduced judicial intervention. Courts began recognizing that prison administrators, not judges, run the prisons. And for us officers, this meant more discretion, but also greater responsibility to avoid abusing it. So in the 1980s and the 90s, the courts continued limiting rights. Rhodes versus Chapman, 1981, where they basically said that double selling is not unconstitutional, which was, if we didn't have this, the prisons would be so overcrowded that they'd have to just keep building prisons for single cell. And then Turner versus Safely, 1987, created the reasonableness test. So basically, that is if a rule is reasonably related to security, it's constitutional. Wilson versus Cedar, 1991, conditions must evolve deliberate indifference to violate the Eighth Amendment. Section 1983 lawsuits remain the main way most inmates challenge rights violations now. We constantly applied the Turner standard, asking whether a restriction was legitimately tied to safety. In a maximum security facility, it almost always was. So in 1996, this was a year after I started, Congress passed the Prison Litigation Reform Act. This dramatically limited inmate lawsuits. So the PLRA required filing fees, exhausted grievance procedures, 3 strikes rule for frivolous filings. Recent cases like Bruce versus Samuels and Lomax versus Ortiz affirmed these limits. The PLRA reduced the number of petty lawsuits. I saw this, but legitimate grievances still made their way into court. Substantive rights. Inmates retain substantive rights, and this is including the right to physical security, the right to basic life conditions, the right to due process protections, the right to challenge their confinements. These rights set the minimum standards officers must uphold, even in high security settings. Safety and humanity must run together. So the First Amendment. First Amendment is the freedom of religion. Religion is one of the most frequently litigated inmate right issues. You can see from these 3 cases, along the State versus Shabazz, Cutter Wilkinson, Religious Freedom Restoration Act of 1983. And I've seen this in many different religious factions housed. Christian, Muslim, Hebrew, Israelite, Native American, Hindu, and so many more. Everyone you could possibly think of, Buddhist. We had to accommodate prayer times, religious diets, and access to chaplains, spiritual leaders, as long as it didn't compromise security. So, another First Amendment, mail and censorship. Mail is another major issue, and these four important cases here. These cases really restricted arbitrary censorship, but it also recognized the prisons may limit mail that threatens security. Um, we had a mailroom. It screened for gang codes, escape plans, and obviously contraband. Contraband like drugs soaked into the envelopes, into the where you take an envelope and you lick the inside of it so it'll stick. Well, that would be laced with drugs. Behind the stamp, it would be laced with drugs. So our mailroom would be checking for that. So we still protected rights, but we also protected dangerous communication in more ways than one. So inmates also have a right to access the courts. They have a right to receive legal materials. They have a right to act as jailhouse lawyers when necessary, and they have a right to communicate with the press under restrictions. Pell versus Perkiner in 1974 upheld restrictions on media interviews inside the prison. We handled many inmates who helped other inmates file legal documents. As long as it didn't undermine security, it was permitted. The Fourth Amendment. So, Fourth Amendment basically gave them protected against unreasonable searches, but not prison. Bell versus Wolfish, Hudson versus Palmer, make it clear that privacy is extremely limited behind bars. We routinely conducted cell searches every day. We had a log. We had to search so many cells a day. Pat downs, obviously, strip searches. We had to seize property all the time, especially if the inmate was acting up. Don't follow the rules, you get something taken. Cause and effect. There's always consequences. So, but all these searches were essential. Weapons, drugs, homemade hooch. All this can turn deadly. So we have to be able to search. They lost that right in prison. So the Eighth Amendment, that governs solitary confinement, physical abuse, inmate on inmate violence, officer on inmate violence. The cases like you see here, especially establish the excessive force by staff violates the Constitution, even without serious injury. I saw both the necessity of force and the importance of using it properly. Documentation, training, professionalism, they were all key. So the deadly force cases like here in Whitney versus Auburn 1986 gave officers leeway when responding to riots or violent emergencies. And then we had the medical rights cases, Newman versus Alabama, Stella Gamble, again, no deliberate indifference. Yeski, 1998, basically the ADA applying to prisons, the American Disabilities Act. Medical care is one of the biggest legal vulnerabilities for prisons. Inmates, especially at PCC, file medical grievances daily. And even delays can become some pretty big legal issues. So a condition becomes unconstitutional when it degrades human dignity, when it is disproportionate, it shocks the conscience, staff show deliberate indifference, punishment targets characteristics like race, due process is ignored. The legal standard guided many decisions, especially applying from segregation, placement to disciplinary actions. So cases like Jackson versus Bishop, Hope versus Pelzer, this ended corporal punishment in the prisons. More modern cases like Farmer and Brennan, Dockery versus Epps, this focus on protecting inmates from the dangerous overall conditions. So Farmer versus Brennan is especially important. It ruled that prisons must protect vulnerable inmates, including transgender individuals. Racial segregation in prisons was challenged by Washington versus Lee, 1966, and then Johnson versus California in 2005. So segregation can't be permanent, but temporary separation can be permitted for the safety and security of the institution. Race was always a factor in housing decisions, not because policy, um, but because inmate gangs were often racially aligned. Courts required us to justify any race-based separation strictly in the terms of safety. So the 14th Amendment rights, again, due process rights and disciplinary hearings, Wolf versus McDonald, 1974. So this established written notice, a hearing, um, the the right to call witnesses when safe, and an impartial decision maker, and also a written explanation. Every ticket that I wrote basically had to meet the Wolf standards. If not, it was thrown out. So cases like Ex parte and Hall, Bounce versus Smith, Johnson versus Avery, this ensures that inmates have meaningful access to legal help. Prisons must either allow jailhouse lawyers, like I said before, or provide alternate legal assistance. Um, we had a law library, and request was based on what kind of materials they needed, and we also had trained inmate clerks. Inmate would basically send a request to the law library, say, I need this such and such case. So basically, most of these inmates became their own lawyer. Uh, they had all the time in the world, so some of them became really good jailhouse lawyers. Some of them were actually getting paid from commissary from other inmates to help with their cases. We had a very extensive law library. We had it's basically like going into a law firm. It just there was so many so many books about every single law that you could possibly think of, and it was kind of really tailored towards prison. The cases that inmates have used over the years. So our law library was very extensive, and it was a privilege as an inmate to work in there as a trained clerk. So inmates need ways to challenge unlawful confinement and unconstitutional conditions, and I think the key components here is legal counsel, the Innocence Project, grievance processes, and the corrections ombudsman. So this is basically improving conditions in adult prisons by monitoring the relationship between prisoners and prison officials. The grievance process was a daily part of operations. It is at any prison. Officers had to document absolutely everything, knowing grievances and lawsuits could follow. Some of the tickets I wrote went to court, and I have been taken to court. So it's inevitable in the prison. You're either going to write somebody up, or you're going to get wrote up by an inmate. That's just it's inevitable. So the key thing is to make sure that when you write your incident reports, when you write your grievances, when you do your tickets, everything's done by the book, because the courts will look at that and you will have to defend that in court. So the impact of prisoners' rights movement. So the prisoners' rights movement improved. It improved overcrowding oversight. It improved access to medical care. It improved sanitation and living conditions. It improved disciplinary fairness. It improved legal access. But overcrowding staff shortages and the PLRA restrictions still challenge modern corrections today. Um, and from my experience, the biggest impact was what we've talked about this before was the professionalization. Officers today really must balance safety with constitutional obligations. And when it's done correctly, both inmates and staff benefit. All right, so a little quicker one today, but I'd like to just close out just by saying that understanding prisoners' rights is essential for anyone entering the criminal justice field. These rights shape everything from officer behavior to inmate expectations. Um, Maximum security prison, like I worked at, respecting rights wasn't just about legal compliance, it was about safety, it was about professionalism, it was about maintaining order. So I thank you again for joining me here in Chapter 8, CJ213. Um, I would say just go back and review some of these cases that we discussed because they are and they do form the backbone of our modern correctional practice. Thank you, and I will see you in the next one.